according to several sector regulators, just being giving that among them we have the UCC area and the steady growth of mergers and acquisitions across telecom markets have really created a strong demand for legal practitioners, for us as lawyers, and
those who are well versed in merger control and competitive practices and agreements, abuse of payment, and the complexities of cross-border regulatory coordination. I do believe it is designed to equip Ugandan advocates with case-driven insights drawn from both regional and domestic regulators, as well as clarify procedural requirements, eliminating emerging enforcement trends, and outline effective compliance strategies for clients operating across multiple jurisdictions. And that is the effect of competition and consumer welfare at the Commercial Competition Commission, whom, like I said earlier, is really experienced, has a lot of knowledge to share with us. And I believe he will provide for us a regional perspective on competition enforcement and its implications for Ugandan markets. I therefore encourage all of you to listen keenly, ask questions, let's engage actively, and we get out of this session with a lot of knowledge. At least each and every one of us has to learn one or two things. For me, it's not just an ordinary training, especially having these new trainers, having all of us know that there's a big challenge for business in this country, but these are the emerging personally, I'm excited to see how the day unfolds. With this exceptional lineup of speakers, I'm not worried, and honestly, we shall get the best of the day. Thank you very much to the best of the day and an interesting discussion. Thank you very much. Over to you, Patrick.
Thank you, Mr. Vice President. And I think with that perpendicular blessing, we're ready to have a radical discussion on competition law today. So, just as a brief introduction, what you should expect from the CLA today. When you hear this term competition law, in a nutshell, what we want the takeaway to be once you leave this training is, this is an area of law that intersects with many disciplines, that has the key objective of regulating how markets function. So different industry players, just to make sure that one, the playing field is level for people who are entering a given market, for people who are playing in that given market, and for the consumers. The key stakeholders that the law is looking out to protect are other players in a market and the consumers. In the simplest way, that's how I can explain it. These competition laws have arisen because over time the governments in different countries have seen that if a particular player in a market amasses so much economic power and they become dominant, they have the power to bully all their competitors. I'll give you an example. In Uganda, we have two major telecom companies, Airtel and MTN. If tomorrow, we know these are very upstanding corporate citizens in Uganda, but if tomorrow they woke up and decided that airtime is going to be sold for 50,000 shillings per minute, because they're the two major players, as consumers, there's not much we can do, but even the small competitors that they have really don't have much of a choice. They would either have to match the 50,000 shillings or go out of business if they cannot match it. So competition law is coming to say that despite the fact that you have all this economic power, despite the fact that you, on your own independently, you can decide to set a price that is unique to you, that is oppressive to your competitors, it is oppressive to your consumers. Is that price fair? Is it based on an economic rationale? Is there a basis for you deciding that airtime should be 50,000 shillings and not 1 shilling a second? In a nutshell, that is what competition law is trying to achieve. I would like to introduce our keynote speaker today, Mr. Boniface Makongo. Mr. Boniface Makongo has a glowing and long CV or experience in this particular field of competition law. He brings regional expertise to this discussion. He was recently the director at the Kenya Competition Authority. He's now the director at COMESA. So you can see that you are in the very best hands. We would like him to explain to us today how COMESA looks at this subject of competition between players in Uganda, players in Kenya, right? How they regulate, the key things that they are looking out for. You as a lawyer, when you're advising someone on a merger transaction or on an acquisition which has a cross-border effect, what should I look out for? Who should I notify? And if I'm aggrieved by something, where do I go? Mr. Makongo, I hope I've done you justice. Please, I'd like you to take up the space and give us your keynote address. The floor is yours.
Thanks a lot for that introduction. I'm having challenges with my camera. I'll be going down it. Nothing important, but if you don't mind, you will allow me to proceed.
Don't mind? You will allow me to proceed, even as my camera is.
Okay.
Seems to have a challenge. The background is black, so I can't be seen. I think, as I have been introduced, my name is Boniface Makongo, Competition and Consumer Welfare at the COMESA Competition Commission. Just by way of introduction, as to why in the first place, as you might be aware, all ensure that they play by the rules, and ensure that they play by the rules. And playing by the rules means that every business approaches the market as an independent entity and compete with other businesses offering the same good. And the benefits of that, one is economic efficiency, because the product is, there's no waste process or in the process of selling. You are always trying to ensure that more of your product gets sold. So you will have to look for a way of making sure that the product that is being offered at the best price that will enable you to sell to people. Secondly, there is the aspect and benefit of you must be innovative. You must offer products that and as a result of this interplay where everybody independently approaching the market and offering their product and ensuring that the product is the best and better than their competitors, you will find that consumers have a variety of goods and services to choose from. The benefits of competition and agency at national level that those who don't play by the rules now sanctioned and now coming to competition at regional level. The objectives of regional bodies like COMESA is to ensure trade. Equally, at regional level, market players could allocate markets. The objectives of the regional market will be impeded. They cannot, because we will be agreeing that you sell your product in Uganda, I sell mine in Kenya, somebody else in Tanzania, another person in Rwanda, and thereby we avoid competition among ourselves. We agree on prices, and as a result, then the consumer in the common market will not benefit from the ensued and liberalized trade. That is why it's of COMESA. It brings together 21 members. I'm aware that Tanzania, Kenya, Rwanda, Burundi, and Uganda, I believe now Southern Sudan and Somalia are equal. I know that Uganda, Kenya, and Rwanda are also members of COMESA. So as I was saying, the founding provide Article 55.1 of the COMESA Treaty agreed to prohibit restrictive business practices. And that is the genesis and the which the COMESA competition. One of the challenges that one would note immediately when you have that kind of framework, one would ask, why do you need to have one in the context of Kenya, for instance, Uganda and Rwanda? We see about competition at COMESA level, and we have a competition agency at national level. Okay, I'm aware that I believe in Uganda, it's part of the Ministry of Trade, is where which enforces competition. It's a jurisdictional issue. At national level, you have a competition in the borders of a state. And I need to mention at this stage that enforcement of competition is a very generic kind of law and statute. So that the things enforced at national level are still the same things that are enforced at regional level. So it so happens that given the nature of trade and the text of integration that I have mentioned, there will be certain practices, especially by big players, by multinational companies that in the countries, instead of having to ensure compliance at national level, there are still instances and abuses and conduct that happens on a cross-border perspective that will require to remedy. So that is the basis on which you have regional bodies to also, in having the national bodies, you also have regional bodies to ensure that both conduct that happens within the country and conduct across borders, because you know who the players are, you share and the market. What you want to, so you have competitive pricing, you have broader economy, you have efficiencies, context. in business is to that they sustain their kind of so what will ultimately result is that these firms will engage in practices to ensure that nobody else enters the market. Whoever else wants to come in is kicked out. They will ensure in practices to do with prices that are unsustainable and excessive because they have control of the market, and many other anti-competitive practices that have a negative impact on the. So when you are looking at market structure, competition as much as possible, you want to know who is coming in, and how we do that is through the merger notification process. So that whenever somebody wants to acquire, is exiting, so if somebody is exiting, somebody else is coming in, you have to seek an approval. And the things you're looking at when you're looking at a merger as a competition agency is two things. One is significant lessening of competition. Competition lessen, as I've just mentioned, the players are assuming a monopolistic position in the market, or players are reducing in a particular market segment. So that has possibilities of coordination, possibilities of unilateral conduct, that is collusion, because you are very few, so you can talk and agree on how to retain the market. So those are some of the things that you're looking at in the merger process to ensure that you are not doing a merger that will result in those outcomes. Secondly, is public interest. In our kind of context, you're aware that in any merger process, if two firms
Recording in progress.
are say producing beer agree to merge, the natural outcome there is that one of the firms or both firms will shed off some jobs. So when we are looking at public interest, the issue of which jobs are being shed and why, what is the justification why you're firing? Of course, the realistic thing is that if you have two directors of finance and you're merging, one director of finance has to leave. If you have two directors of human resource and you're merging, one director of human resource may have to leave. So we still have to get a justification on who is being let go of and why. Other things that we look at in the context of public interest when we are assessing a merger is also things to do with SMEs. Once somebody is acquiring a firm that was relying or supporting a lot of SMEs, so you say you are a supermarket, you're being acquired, and there are a lot of SMEs that are supplying goods to you. They're supplying matoke to you. They're supplying other things to you. And they want to retain those terms. A competition agency should be keen to ensure that the terms that this new entrant in the market is coming in are similar to those that or rather, they are not disadvantageous to the SMEs that are currently incumbent in that particular space and the ones that are supplying that particular company. Other issues that we look at, and by the public interest is a very broad area, so there are so many things that you will look at. There would even be issues of production. That sometimes you find firms, especially global firms, coming in to try and purchase a manufacturing entity to close it down so that they can import instead of manufacturing locally things. With regard to the other aspect, which is market conduct. So market conduct has two main facets. What is the area around collusion and other anti-competitive business practices that I've mentioned in passing around things to do with agreeing on prices. Some entities may also be allocating markets. You could be engaged in collusive bidding, where you agree in the context of public procurement to say, let me bid this time, and you bid next time. So that cost toward like roads and related issues, very high. So that is one aspect of it. The other aspect of it is the area that was alluded to earlier during the introduction on abuse of dominance. So abuse of dominance is in different laws, there would be a threshold set on what dominance amounts to. In COMESA, in the context of COMESA, it's having 30% of market share. I'm aware in Kenya, it's up to 50% of that firm is dominant. Now, an important thing to note is that being a dominant firm is not illegal per se. It's not prohibited to be dominant. What is prohibited are abuse of that dominance. So you could be a dominant player, then you start imposing the similar conditions, for instance. So for this set of players, you impose a price of this much. Another set of players who are probably smaller in the market and therefore not as valuable to you as a dominant player, you impose much higher prices because you're a dominant firm. You could be engaged in predatory pricing. You're pricing products below the average variable, cost of producing that product to force other players out of that market so that you can then increase your price after they have exited and exploit consumers. It could be issues to do with price fixing. It could be issues to do with retail price maintenance, where you are setting prices at which your products should be sold and sanctioning to ensure that whoever does not sell at that price is sanctioned or in some way forced out of selling your product. So those are some of the things that we look at when we are investigating things to do with abuse of dominant position. So those broadly would be what fall under the second limb of enforcement of competition, which is with regard to conduct. The other previous one being structure. Now, on conduct, also there are emerging issues that I need to mention. One of the emerging issues here is the issue of platforms. One of the things that we have seen emerging is that in the context of the big platforms that we have, your Googles, your Apple, and many other platforms, Facebook, they would be conduct that they're engaged in that is anti-competitive. But the challenge we've had is that we realize that because of the nature of the business they're engaged in, the fact that, for instance, they don't charge any price, the kind of legal framework that we've been having is not very effective in addressing the challenges posed by those particular entities. So what we've done is we have made amendments, have had to make amendments to our regulations. So going forward, we will be empowered to be in a position to investigate and sanction also those platforms. The other is an emerging area that has also been tackled by amendments to our regulation around abuse of economic dependence. This is not strictly speaking a competition area, but it's an emerging area, especially in the context of developing countries. And a good example I can give you is this. When you're supplying, say, a supermarket, you're a supplier to a supermarket, maybe you're selling vegetables to them, or you're selling them any other product, yogurt, juice, whatever else you could be selling to them. In our kind of context, there has emerged a practice where supplier credit is used to expand farms and engage in other unrelated, activities. And as a result, you end up in a lot of mortality of SMEs. So you supply to a supermarket, they agree from the onset that they will be paying you within 60 days. But after the 60 days lapse, you don't get paid. You're asked to supply more so that you can be paid. And it goes on. And ultimately, they end up with a debt to suppliers that they cannot afford. In the context of Kenya, you might be aware, because some of these supermarkets also operated, I think, initially also in Uganda, like Tuskys, Nakumat, Uchumi. That led to the collapse of those entities. So it was realized that you need to have an agency that can ensure that whatever terms are agreed to, there is compliance. So that is why we have what in some contexts is called abuse of buyer power now coming up as an additional area of enforcement by competition agencies. In the context of the region or in other places, it's also called abuse of economic dependence, which is slightly wider. Now, I probably need to mention something about the actual investigation and how we handle mergers. So mergers essentially is to ensure that you don't have duplicity. We normally ensure that as much as possible, and also in the interest of business, because again, it's good to ensure and mention that we are not in the business of ensuring that businesses collapse. No, we want to facilitate business. The objective of having competition is consumer welfare, yes, but again, we are not here to somehow impose roadblocks on businesses so that they collapse. We want them to play by the rules for the benefit of consumers. So we ensure also that we do not impose a regulatory regime which results in making it more difficult for businesses to operate. How we achieve that is through having a one-stop regime, so that at regional level, if a merger is notifiable to COMESA, the same merger should not be notified at national level. That has worked very well for us so far. There is a slight challenge around the ESC, but we are trying to resolve it to ensure that transactions are still notified at one stop. So it's either in the ESC, at COMESA, or at national level. And how we do that is by having thresholds. So you would say that a transaction of a particular size is notifiable at national level. So just to give an example, currently the thresholds that are applicable, just to give an example of Kenya, which I'm very conversant with, and COMESA, at national level, transactions that are notified at national level is a transaction which the total of the target and the acquirer. In the context of a merger, the firm that is acquiring the other is called an acquirer, and the one that is being taken over or acquired is called the target. So both those should have at least 1 billion in turnover. And additionally, the target should have at least 500. Those are Kenya shillings. At COMESA level, the target is slightly more higher. Currently, based on our new regulations, both the acquirer and the target should have at least $60 million. The target should have at least, both entities, i.e. the acquirer and the target, should have a turnover of at least $10 million. In addition, both the target and the acquirer should operate in at least 2 or more member states. So how that is interpreted is either the acquirer operates in 2 or more member states, both the acquirer and the target operates in at least 2 or more member states, or the target operates in 2 or more member states. And lastly, 2/3 of the turnover I mentioned earlier, of both the target and the acquirer. So none of these $10 million that I talked about, which either the acquirer or the target should be in one and the same member state. So with those thresholds, you ensure that there is some clarity in order to ensure that you don't have a transaction that is notifiable at both levels. Now, the actual notification process is this. Once you confirm that your particular transaction is notifiable at, say, COMESA, the requirement is that you fill a form. There's a form on our website, our Form 12, and it has quite a number of requirements in terms of description of your parties, where they're operating, the sector they operate in, the market shares, and many other details. And in addition, you're also supposed to submit financial statements for at least 3 years. This is equally the case in the case of a transaction notifiable at national level. You still have to fill a form, and the details are relatively similar, except for the ones that speak to the regional aspect in the context of a regional transaction. Then after that, we will review that transaction, and we are required to get back to you within 120 days. Though the practice is that transactions are reviewed in a shorter period than that. And in the context of reviewing the transaction at regional level, we would engage the member states that have a nexus to that transaction. So if those entities, both the acquirer and the target, operate in Uganda and other countries that they operate in, or they sell their products to, or they export to, we will engage those countries to tell us about the effect of that transaction, both in terms of the market shares, the competition dynamics of the sectors they operate in, and what I mentioned about public interest. So after receiving submissions from member states, and we also have on our website, we put out a notice inviting the general public to give us information on that transaction and any competition concerns that they perceive might result from it. Those then go into our analysis of that transaction. And just to add that when we are analyzing the transaction, there are 3 outcomes that are possible. One is to say that this transaction does not raise any competition concerns, approve it unconditionally. 2 is to say that based on our analysis, we determine that it's raising competition concerns or public interest concerns, in which case we allow the parties to give us remedies. How can they, based on their knowledge of the market, what do they think is the most efficacious way of addressing the competition concerns that the Commission will have identified? So they'll come back to us and say, look, we have reviewed your report, and we think, one, that probably this competition concern is not valid for this reason. And we will review that. And if we agree with them, we'll drop that competition concern. Or if we don't agree with them, we will insist for them to submit a remedy. And in most cases, they will structure a remedy to address the concern that will be identified. So for instance, if it's a competition concern that to say, as a result of this transaction, the only 2 players or 3 players in a particular sector will become one, and that therefore results in a monopoly. It could be that they offer to sell off one. So we are only acquiring this one, we are not acquiring this other. Because if we acquire all the 3, this will result in the transaction not being approved. That is one way of structuring it. With regard to public interest concerns, they could offer to absorb a particular number of people for a particular period. Now that I'm addressing lawyers, it's good to also mention your role in this whole process. Suffice to just state that this entire process of merger filing, engaging on remedies, up to the approval, is typically done by lawyers. So this is basically legal work. There is nobody else who is involved. It's a It's an area of practice, just like other areas of practice, just like traffic, criminal law. It's an aspect of commercial law. So the third outcome that is possible is we could decline. If we find, for instance, that this is going to lead to a monopoly situation happening or elimination of the only other competitor, we could decline, and that is the end of that transaction. The commission has made a decision that you disagree with as the lawyer for the party. You are not without remedy. You are allowed, in the previous regulations, which have now been repealed, there was provision for you to appeal to an appeals board within the commission. So basically, this would be 5 board members who never, dealt with that particular matter, sitting to listen to the merits of your case in a typical appeal kind of scenario, which is common in what we'll do maybe even in courts. So you file the appeal, they review it, they might either agree with you or disagree with you. But currently, the law has changed. So once you're not satisfied with the finding of the commission, you appeal to the COMESA Court of Justice. There is the Court of First Instance, and appeals from that will lie, I believe, in the appeals chamber of the COMESA Court of Justice. And whatever outcomes then that result from that will be final. Now, with regard to anti-competitive business practices, which I mentioned earlier, when you're looking at cases, the commission will hear either or that there is a possibility that firms or one firm is engaged in a particular conduct, say collusion. So what is the screening of the matter and review of the facts of the matter? The commission will write to your client, serve them with a notice, tell them, seeking information on various aspects of the operation, agreements, and related issues. And after review of that information, and in most cases, undertaking a field study where you engage with stakeholders in that particular sector, it could be possible that we find that there is no contravention. So the matter ends there. However, also, it could be after that preliminary review of the matter, we find that there is evidence to suggest that there is a contravention going on. So in that case, we will serve your client with what we call a statement of concern. So this is the equivalent of a charge sheet. So this will lay out the allegation, the contravention that is suspected, will have found, and give you client to respond, file in any typical investigation. So your client will review that, or you review it on your behalf of your client, then you will file a response to that. So once you file a response to that, we will again relook at the matter that we had investigated, compare the evidence with what your client would have established. And I'm not in prevention of this one, and based on that, I don't think the commission has made a case. Process could be 2 things. One, we could that your client has submitted substantively evidence that demonstrates that they are not in contravention. And based on that, we will let them go. We'll write to them and tell them we've closed our matter investigation. Thank you. Or establish that there are certain contraventions that have been proven and others have not been proven. So if that is the case, we will proceed, of course, with the ones which have been proven, or if everything has been proven, even after reviewing the defense by your client, we will proceed and serve your client with a report which we submit to the decision-making body in the commission, which is the committee which basically the CID, which reviews our determinations, and you will be given an opportunity to appear before that body, i.e. the board at COMESA, and reiterate why you still feel that you have not contravened any of the regulations. So what you're seeing emerging is a scenario where, as much as possible, due process is being inculcated in all our procedures. So after that, the Committee for Initial Determination then can either agree with you and dismiss the matter again, or they could reach a finding that is adverse to your client. And after that, you are still allowed to appeal to the COMESA Court of Justice, which I mentioned earlier. When that happens, then of course we go to the COMESA Court of Justice and we proceed like that. I think also it's good to mention about the remedies. And these remedies are very generic also, just like the contraventions themselves, both at national level and at regional level. There's a provision for a penalty of up to 10%. But typically for investigations, the remedies would be about ceasing from the conduct that you have been found to have contravened. So if it's an agreement, you expunge the provisions that are in contravention, because of course agreements will have many other provisions. So we are only interested in the ones that are in contravention regulation. So you expand those and you pay a penalty. And even in the process of determining that penalty, lawyers will still be engaged in raising, mitigating, and aggravating circumstances to lower the penalty in this case. Lastly, I think with regard to conduct cases, I'd just like to inform you that, and it's good for us to note that a competition agency, both at national and regional level, are also empowered to issue interim orders. So if we commence an investigation, and in the course of the investigation, we find that the conduct that is being investigated is very egregious. You are about, for instance, to engage in a price fixing agreement. We do issue interim orders to stop you from engaging in that conduct before we even commence investigations, even as we continue with the investigations that I mentioned earlier. Lastly is the issue of settlement. So I did mention that once we go to the CID, you will appear and defend your client's position, and the CID will make a decision. That is the adversarial route. Sometimes your client would opt for a settlement. An interesting aspect of settlement is just like a consent order, that you agree on resolving the matter and you address the concerns of the commission. And of course, it could still involve a penalty or not. But this is now negotiated. So immediately we come back to you with the SOC to tell you that we still feel that there's a contravention that your client has engaged in. You could opt for settlement. So that one is a much more, what I would call amicable way of resolving the competition concern. But once we have agreed on that settlement, we'll still go to the CID to record it. An important aspect of settlements in competition cases is that it's possible to agree to a settlement on a no liability basis. So you're saying, I'm not in contravention, but nevertheless, let's resolve your issues in this manner. So that is a very unique aspect that tends to happen in competition cases. Now, lastly, with regard to the cases that we've handled, just to note that at regional level, we've handled a total of 309 mergers since 2013 when we started operations. And these have led to investments in various sectors in the common market of $325 billion. And with regard to Uganda, the mergers that we've handled that have a bearing on Uganda, you remember I talked about nexus, transactions having a nexus, at 261. The leading in terms of the out of the 390, 381 cases had a nexus with Kenya, 343 Zambia, 325 Mauritius. The other notable cases is Uganda 261, Egypt 230, Ethiopia 218, DRC 258. Now, with regard to conduct cases, we've handled a total of 71 cases that have been investigated, some resulting in some kind of penalty. Others have been closed at various stages. Uganda has been involved, or rather, the ones which have an access to Uganda were 28 of those cases. I'd like to stop there. Thank you very much.
Thank you so much, Mr. Makongo. I think I speak for the entire membership when I say this presentation has been really, really in-depth, really clear and understandable. I think we are all now experts in this thing that we're calling COMESA competition regulation. Mr. Makongo, we have a few questions from the membership which I'm going to put forward, but before that, I want to exercise my discretion as the moderator to ask my own questions first, and then the members' questions will follow thereafter. I wanted to ask, there's something you touched upon that the Competition Commission at COMESA has done as much as possible to harmonize the process of merger approvals to have a kind of one-stop shop, so that if I have a merger which has a cross-border effect, for example, the merging companies have a presence in Uganda and Kenya, which are both COMESA countries, and their revenues or the transaction value exceeds the thresholds that you've talked about. I don't need to go and notify at Uganda, at Kenya, and then at COMESA, right? There's a harmonization that I only notify at COMESA. You've touched upon the fact that the East African Competition Authority, which has just been implemented and come into force, has not yet harmonized, and there's a bit of friction there. There may be a requirement for dual notification until the harmonization is completed. I wanted to ask, now that we have the African Continental Free Trade Area Protocol and competition policy coming into force, how will that work together to ensure that we have an Africa-wide one-stop shop regulator beyond the COMESA region, but as well as FCFTA, let's say it's a West African merger under the African Continental Free Trade Area instrument, right? Is there any policy, any intention to harmonize at a continental level? Is this something that the Competition Commission is looking at? Would really be keen to hear your thoughts around that. Yes.
Okay.
Thank you very much. As I mentioned, just to restate, it's true that we With regard to the national and COMESA right now, we have had what I would call success in ensuring that we have maintain a one-stop shop, so that transactions either come to us or they go to the national authority, for those that have national authority. So that has been a success. To mention that, and I think I mentioned it, even as we do it at our level, we ensure that whatever competition concerns are going or likely to arise in a particular jurisdiction are taken care of, even if the transaction is being notified to ourselves at COMESA. So that is why we engage the member states to give us submissions on any competition or public interest concerns that a particular transaction will raise. And also to ensure that that system works, all the money that I hadn't mentioned about the merger fees, I think it didn't come out, but currently we charge $200,000. That's the maximum charge we have. But it's supposed to 0.1% of the total transaction fee. Remember, I talked about the acquirer and the target having a particular turnover. So that is what is used to determine the fees, up to a maximum of 200,000. But in our new regulations, we want to adjust that to 300,000. So half of that money is also shared with member states on a prorated basis. So you note, I told you about the 300 transactions for Uganda, 300 and something and all that. So that is how you, so if that particular transaction has an nexus, the particular countries it has a nexus with, we use the turnovers in those countries over the total of the turnover in the common market, and we get a share of that particular country's share, which is then sent to them. That is half of our merger filing fees. Now, with regard to EACA, that is the East African Competition Authority, we are still working out modalities. They are very receptive, and I think this is something that will work very well. Of course, there are areas of duplication resulting from, among others, the fact that there are countries in both bodies that do not. So, for instance, you have countries in COMESA that are not in EACA, and also in EAC, and equally countries in EAC that are not members of COMESA. So there's a challenge there, but there's goodwill to ensure that because all countries recognize the importance to have a harmonized system. We just don't want to have bureaucratic agencies that are requiring basically bureaucratic impediments to business in the common market and also in the EAC. So there is a lot of hope that that will be addressed. With regard to the African Continental Free Trade Area, if you look at the competition protocol that has been agreed, one of the things that is very clear with regard to the jurisdiction and mandate of the African Competition Free Trade Area Authority that is going to be established is that matters falling within the purview of regional competition agencies do not fall within the mandate of that authority. So this is very clear in the protocol itself. So if a matter is meets the thresholds for notification in COMESA or EAC, or the one in ECOWAS or WAEMU, it will not meet the thresholds for notification at the African Continental Free Trade Area. So we think that will go a long way in ensuring that areas of potential duplication are addressed, bearing in mind that the continental body would also be a very, very, I would say, it seems like it's going to be more difficult to implement than, say, the EU because of the size and diversity of Africa. So what we've tried to do is to, because the African countries are not keen on doing away with any regional bloc. The intention of our member states in both the AU and COMESA and EAC is to retain everything as is. So they've tried to have a framework that ensures that there's some kind of harmony among all those institutions. So in the context of the AfCFTA, matters that fall within the regional competition authorities will not fall within its mandate. Thank you.
Okay. Perhaps the other question that I have, which we've received from our members, as lawyers, we all want to serve our clients as efficiently as possible. From your perspective, Insight as a regulator, first at Kenya and now at the COMESA level, what is the single most effective thing a lawyer can do in their initial filing to ensure a faster review, to ensure that we are proactive in getting our mergers approved, and for continuous compliance? What are the most effective tips and tricks that you can give us as lawyers for our practice, looking forward to COMESA compliance and merger approvals?
Yes, thank you very much. With regard to ensuring that
you have an expedited approval as a lawyer, because when you start doing merger work, for instance, you will note that the most important thing that your clients want is speed. They want their transactions to be dealt with and determinations issued in the shortest time possible. I need to add that this is an area that is a big challenge to a lot of African law firms, because this has tended to be an area so far that is largely dominated by law firms from outside Africa, or the ones that are very established within the African continent. So this is not, as much as possible, I think we need to have a future where this is technical work that anybody can do, because it's not actually complicated. So there's need for first of all, for lawyers to publicize within their respective jurisdictions that this is work they can do, so that instead of people being brought in from Europe and other places to do work in South Africa, we have more lawyers coming from say Uganda, because Uganda, I think, has been really missing in action in this area. Kenya has really tried in terms of having an increase over the years in the number of lawyers coming to us. Now, coming to your question specifically, the way we ensure that your clients' approvals are expedited is basically submitting whatever information that is required expediently. So you look at the form, everything that is required, make sure it's submitted. We are always available in case there's any clarification. And we, based on due process also, we are supposed to give you time whenever we ask for information. So we give you time. So if you are able to revert to us, quickly, then we likewise would be in a position to issue a determination, as quickly as we can. Typically in COMESA, we have around 5 to 6 CID meetings in a year, and this would be the way they are spaced is like every 2 months you would have a meeting. So if you've submitted all the information, the member states have submitted their submissions, we must relatively quickly in the circumstances. Another thing that you need to be alive to is that where you have doubt, because some of these transactions or all this business of thresholds and all that, before you really get into it, there could be a lot of issues you have to ask. We are always available. You can ask for a comfort letter if you are not very sure that your client should be notifying. So we provide comfort letters. We don't charge for those. Those are free. You just write to us, describe to us the transaction. In case we need more information, we get back to you. And we issue you a comfort letter telling you that this transaction, based on information that you've submitted to us, is either notifiable or not. So that's another avenue that you can take advantage of to ensure that you are always advising your clients which transactions should be filed, how quickly they should be filed. Just to mention that also, it's good to tell your client, and these lawyers need to know, that if you don't file a notifiable transaction, your clients runs the risk of being penalized up to 10% of their turnover. So that is a serious deterrent penalty that will be imposed. So that essentially is how you go about ensuring that your transaction is if it's notifiable, it's notified, and in case any information is sought, you always give us the information quickly so that we're able also to turn around your transaction. Thank you.
Okay. Thank you, Boniface. Thank you so much for the time that you've taken to speak to our membership. I believe that personally, I have learned a lot from the practical aspects relating to the COMESA aspects of competition regulation, merger approvals, conduct which may be anti-competitive. We truly appreciate your time, and we hope that you'll stay with us towards the end of this session to have some parting remarks and the broader Q&A section from the membership. Thank you so much, Boniface.
Thank you too.
Okay, members, we're moving on to our second presentation of the morning. This presentation is going to be made by Ms. Sophia Nampija. She's a partner at Katende and Sempebwa. Her practice is really as a corporate and commercial lawyer, specializing in mergers and acquisitions, competition compliance, and regulatory advice for multinationals and regional clients. She has advised her clients on several high-value cross-border transactions requiring COMESA merger notifications, working closely with telecommunications, health, insurance, and financial services clients on competition and regulatory issues. She's dual qualified, admitted to the bar in Uganda and in New York, and is a member of the Association of International Petroleum Negotiators. She has advised on the $3.5 billion ECOP financing and has advised the government of Uganda on its first greenfield oil refinery. She holds a postgraduate diploma from the East African School of Taxation and sits on the UNBS Technical Committee for Petroleum Standards. We brought you only the best for today. Sophia will be speaking to us about the salient features of the Competition Act, CAP 66 of 2024, and the Competition Regulations 2025, to give you a general understanding. What is competition from a Ugandan perspective? What are the institutional makeup of the regulators at the ministry? What are the obligations? What is the structure of the law administratively? Yeah. Thank you so much, Sophia. Please, the floor is yours.
Morning. Good morning, Patrick. Please confirm that you can hear me.
Yes, we can. Yes, we can.
Can you hear me?
Oh, yes, we can, Sophia.
Okay. Good morning, members of the Ugandan Law Society. It's an honor to have been invited to make this presentation to you on the general landscape of competition law in Uganda. I would like to thank the previous presenter for that detailed, in-depth, and very relevant summary of the regional aspects of compliance with competition frameworks. I think this is a good it's a good segue for me to, coming from that, looking at the regional and looking at the regional framework, to now move into the national framework. So I'll try to project, or I don't know if Patrick, you were able to project on that end, the presentation which was prepared for.
Yes,
today.
yes, we can. We're going to just put it up in a few minutes. Yes, it's just going up. right now. I hope it can be seen.
Yes, I can see it. Thank you.
Okay.
So the presentation today will cover the new landscape of competition law in Uganda, particularly with the recent enactment of the Competition Act and regulations. Patrick, if you can move to the next slide.
Okay. Apologies.
We're going to look at, in this presentation, we're going to look at about maybe 6 key areas. We'll start with just a general overview of the relevant domestic laws. We will look at the institutional infrastructure. We will look at interface with the sectoral regulation and competition. And then we'll delve a little bit into the Act to look at what are the core regulated activities or conduct. Then we will look at penalties, the current enforcement landscape, and then a few key takeaways that every practitioner in this space ought to consider. So in terms of landscape, so we're going, I'll start by just giving a short primer on the timeline. So I think in Uganda, we started talking about having a national competition framework as early as the 90s. But it was around 1998 where the first draft of the competition bill came through, which was later prepared as the competition bill of 2004. This bill was never passed in Parliament because it was criticized for lacking major frameworks for the protection major frameworks for the regulation and control of competition within the market. It didn't have, I think there was no requirement to investigate or powers to investigate market conduct and a few other regulations. So fast forward 2014, the first time we had the National Competition and Consumer Protection Policy, which finally developed into the competition bill that was tabled in Parliament in 2022. This bill was eventually passed a year later, on 1st September 2023, and received presidential assent in February 2024, and finally was gazetted and became operational on 19th April 2024. This bill was mostly a framework which was operationalized by the competition regulations of 2025. So it's been a long time coming, a period of about 26 years if you're counting. Mr. Makongo has very adeptly covered the regional context of things. But for the lawyers who want to know what are the relevant laws applicable, COMESA, I think, was originally created under the COMESA framework was originally created under the 2004 COMESA competition regulations and rules. And I think it's also what established what was then called the COMESA Competition Commission. As of 5th December 2025, this is a couple of weeks ago, this framework, as Mr. Makongo has also alluded to, was reformed. And now we have the COMESA Competition and Consumer Protection Regulations of 2025 and the COMESA Competition and Consumer Protection Regulations of 2025 as the applicable law. In addition to that, the regulator will remain the COMESA Competition Commission, but it now has a new name, which is COMESA Competition and Consumer Protection Commission. So you will note that the law and the regulator have all added consumer protection as a specific to its mandate. And in terms of the other areas that have been added to the other areas of reform, I think Mr. Makongo has gone through a bit of that, increase in thresholds and new areas that they will be focusing on, like digital platforms, regulation of digital platforms, among others. On the ESC front, we have the East African Community Competition Act, which is a 2006 act. Application will gain force of law on 1st December 2014. The regulator is the East African Community Competition Authority, who by notice commenced operations on 1st November 2025. Again, very recently. Mr. Makongo commented on when it will, I think, commented on how there's still efforts in place, harmonization between the COMESA and ESC to see how, and as well as regional laws, to see how we can harmonize the filing requirements and compliance requirements under the three laws without creating duplicity. Going into the Act, this is the Competition Act. When I refer to Act for purposes of this discussion, we'll be looking at the Competition Act and regulations. So all reference to Act and regulations will be to the Competition Act and regulations of Uganda. So the main objectives and regulatory priorities, the main objectives are promotion of fair competition in markets within Uganda and prevention of practices which have an adverse effect on competition in markets in Uganda. The key substantive prohibitions are around anti-competitive practices and agreements, abuse of dominant position, and merger control. And we'll look at what these mean shortly. In terms of institutional, in terms of constitutional infrastructure, the regulator in the Act, or the administrator of the Act, is the ministry responsible for trade, who will be assisted by the Technical Committee on Competition and Consumer Protection. This committee will compose of 7 members who will be sourced from the government, private sector, and academia. As of today, or from the best of my knowledge, this committee has not yet been constituted, but as we have a representative from this now autonomous statutory body. It is a department within the Ministry of Trade. So obviously there will be concerns. There'll be concerns on independence, where the government is, where the complaints leveled against government, how this will be looked at by the technical committee. Noting that it is a member of the executive and is bound by certain executive decisions. There are cases in which, the cases highlighted there are cases in which certain commercial activities the government has taken have been found to be anti-competitive. So, here we'll be looking at whether the technical committee or the Ministry of Trade dispense independence when looking at some of these, if they were to be brought before them. This is, again, I'll note that this is a break. In fact, global trend, where the authority is usually structured as an independent authority. In Tanzania, you have the Fair Competition Commission, and in Kenya, you have the Competition Authority of Kenya as separate independent statutory bodies with an appellate process to tribunals and thereafter to the courts of law. In Uganda, you may ask why. Why was our structured like this? In the original versions of the bill, the Competition Bill 2022, it had been proposed to have a separate independent authority. However, because government had already embarked on the rationalization of government agencies' effort to mainstream authorities, agencies, and commissions under their parent ministries, the president declined to assent to the initial version of the bill and sent it back to specifically have that authority rationalized under the Ministry of Trade. What kind of authority has the ministry been given? The ministry has very broad powers, investigative powers over conduct or what is deemed to be anti-competitive conduct, and they can receive complaints from the public. Matters can be referred to them from any concerned party. Particularly here, you'll see from sector regulators, and then also on their own initiative through knowledge or information received from any other sources. And once they receive these facts or information, they'll have the obligation to first make a preliminary inquiry, just as with COMESA, and then determine whether there's a prima facie case, to then move into a fully fledged investigation. And once they deem that there's a violation or maybe a violation, then they have broad powers to penalize or require rectification. But we'll look at that later on, the kind of penalties that can be given for non-compliance with the Act and regulations. In terms of initiation of complaints, how do you initiate a complaint before the committee? There is a specific form prescribed by law. These have all not been tested. I'm just presenting as is provided in the Act. Again, because the competition, the technical committee has not yet been constituted or operationalized. So, but the important to note is that this complaint may be made anonymously. So competitors, for employees, or other related parties are able to raise complaints without the fear of exposure. Then the ministry will conduct the preliminary inquiry, which I previously alluded to, and then determine whether necessary to investigate. It may ask for additional information. It will require parties to the complaint or named in the complaint to appear, to make submissions or representations, and then make a decision. And we'll see what kind of decisions that they can make. But this is very similar to the framework, the COMESA framework, which Mr. Makongo so ably illustrated. And important to note also is if there's an ongoing court process, then the ministry will not make an inquiry into that matter. What is the interface with sectoral regulators or regulation? So prior to the enactment of the Competition Act and regulations, there are several sector-specific competition frameworks in place. I've highlighted here a few of the key ones. We have in the financial sector, you have the Bank of Uganda, which is mandated to regulate competition under the Consumer Protection Guidelines of 2011. We have, under the Communications Act and the Competition Regulations of 2019, the Uganda Communications Commission is also given broad powers to regulate competition in the communication sector. And I think in terms of regulators, the Uganda Communications Commission has been the most active so far. There are a number of cases that they have decided, popular among them being the Ubuntu versus ATC case of 2022. You have more recently the Vast Garage case versus MTN, and then the older case of Easy Money versus MTN Uganda. Other areas with the sector-specific regulation include the insurance sector, where the Insurance Regulatory Authority has powers to regulate competition within the insurance sector. You have the Electricity Regulatory Authority and the Petroleum Authority of Uganda under the midstream and upstream laws. The Capital Markets Authority also has powers under the Takeover and Mergers regulations to regulate takeovers in listed companies. And then you also have the Ministry of Energy under the Mining and Minerals Act, as well as the Petroleum Supply Act, who is given broad powers to regulate cartel conduct, and several others. Here, the point to note is there appears to be a mandatory requirement to refer competition matters to the ministry, where the law the Act requires, I think, under Section 6, that where during proceedings of a statutory body, a party alleges that the matter may have the decision to be made by the statutory authority may have an impact on competition, then the statutory body is required. There's a mandatory requirement for that. There's a mandatory requirement for that statutory body to refer the matter to the Ministry of Trade. And once that matter is referred, it has two impacts. One, the statutory body cannot make a decision until they've received the opinion of the Ministry of Trade. And two, once that decision is issued, then the committee, the statutory body is required to take it into consideration. So the question here is, required to take it into consideration, is that a mandatory requirement to accept, or they can take it into consideration but vary? Secondly, for regulated sectors, players in regulated sectors, what is the forum? Are they required to, so if they have a competition complaint, is this placed before the regulatory body, or do you go to the ministry? And in cases where none of the parties raises, the ministry or the regulated entity, the player do not raise the issue of competition during proceedings, does that mean that the sectoral committee can hear and determine this matter and it will be binding, or can this be annulled by the ministry subsequently? Also important to consider here is, does this affect the unlimited powers of the High Court to still listen to matters of competition? Is a sector player bound to is a sector player now bound to refer matters of competition to the ministry, or they can pick and choose whether to submit to the High Court? I think as the technical committee sets up and the ministry prepares to hear these complaints, they may need there may be need for a clear framework for collaboration, again, to manage duplicity and to create certainty for players in these markets. So going to the three main restricted or prohibitions under the Act, the first one is anti-competitive practices and agreements. And the question is, what is an anti-competitive practice or agreement? The Act defines this as a practice or agreement which involves the taking of a decision or engaging in any concerted action or concerted practice in respect of production, distribution, supply, or control of goods, or the provision of services which causes or is likely to cause an adverse effect on competition. So the overall test will be whether that practice is likely to cause an adverse effect on competition. In terms of agreements, specifically, the Act mentions vertical agreements as well as horizontal agreements. Vertical agreements are those agreements which entered between two or more firms along the same along the supply chain. This could be manufacturers and distributors, or distributors and suppliers, or distributor and a customer. And certain examples that we have in practice are franchising agreements, exclusive agreements. So these vertical agreements in and of themselves are not anti-competitive, but we will see when they become. When do they become anti-competitive? Horizontal agreements, on the other hand, agreements entered in between firms operating at the same level of trade, for example, between two manufacturers or distributors. And in terms of when do these agreements become anti-competitive? So I mentioned not here, but you'll notice the Act doesn't have a word cartel in it. Instead uses the term concerted action or practice, and this is where you have cartel conduct regulated. So what means when is a horizontal agreement? Horizontal again is where you have two entities at the same level. So for instance, previous question was asked to AT&T and Airtel if they decided to, what would be some of the issues. So I think I shouldn't use much. So if you have a horizontal agreement, if they entered into a separate agreement, how will the Technical Committee, Ministry of Trade, what will they be looking out for to determine whether this agreement is anti-competitive? So they'll look at things like price fixing. They will look at things like limit to controls on production, supply markets, technical development or investment. They will look at things like distribution of markets and sharing markets, either by territory or customers, and any conduct that results in bid rigging or collusive tendering, that is manipulation of. For the vertical agreements, these are the usual contracts between different persons along the chain. Manufacturer again and distributor or franchising agreement. Here they'll just look at whether they are tying arrangements, anti-competitive tying arrangements. Are you forcing the other party to the agreement to take on products or services which they don't need, and withholding supply of services or products until they accept those terms? So anti-competitive tying arrangements, look at exclusive distribution agreements. Again, here it's not all exclusive supply agreements or distribution agreements that will be rendered anti-competitive. It's only if this will have an adverse effect on competition. Again, in terms of what kind of assessment will the regulator, that is the Ministry of Trade, assisted by the Technical Committee, what of determining whether a certain agreement or practice is anti-competitive, they will look at whether the creation of barriers in practice preventing other new players from accessing or entering into that market. And we have seen cases already decided. I think the Ubuntu versus ATC case I spoke of earlier is a classic example of where the right of refusal clause within the master tower sharing agreement between ATC and Airtel was struck down because it was a barrier to entry for new players in the in that sector. Then they also consider forces. Are there forces existing competitors out of the market? So there's barrier to entry, and then they are looking for people who are already in the market, but then by virtue of your agreement or your practice, you force them out of the market. And I guess this is something that was also looked at in the Vast Garage case versus MTN. Then does your agreement or contract result in any consumer or competitive effect? So these are some of the public interest concerns that my colleague, Mr. Makongo, referred to, that the agreement or practice reported may be anti-competitive, but they'll also look at, okay, is there a pro-competitive impact? Does it contribute to production and distribution? Does it promote technical and economic progress, or allow consumers a fair share of the benefits? Then in such cases, they may consider that even when the specific conduct is anti-competitive, it meets all the factors and thresholds considered, but the benefit overrides any negative impacts that agreement may have. Then I'll just touch on this very briefly because I'm aware that one of the panelists is looking at this in detail. But the other conduct which is controlled or regulated by the Competition Act is abuse of dominant position. As Mr. Makongo rightly said, being a dominant player or enjoying a position of dominance in and of itself is not illegal. It is when you abuse that conduct to foreclose competition in that market. And who is a dominant player? There are several factors considered in the Act. The main one being, do you control at least 30% of the market individually, or together with other persons, do you control 60% of the market? Other factors they will look at, or other factual tests include the size and resources, size and importance of your competitors. So you may have market share, but your competitors are equally big. And they'll determine that you did not abuse your dominance. Then dependence of consumers on the goods or services, meaning withdrawal of those goods or services, will be deemed abuse of dominance. Creation of a monopoly and the lack of countervailing market power of that person will all be considered together with, in addition to many other factors that will be considered. But the next player will be looking at this. So these are some of the instances of abuse of dominant position under the Competition Act and regulations. It's broad. We have things like denial of market access. You have predatory pricing, again, which Mr. Makongo ably explained, where you charge really low prices to drive out the competition and then later increase your prices. We have price squeezing, refusal to deal, and the tying arrangements, which I previously spoke about. And these, I think, the next presenter will go into detail over. The third area, which is heavily, which is a focus of regulation under the Competition Act and regulations, is merger control. And what is a merger? The Act, whereas I called it merger control, the Act regulates merger activity, joint ventures, as well as acquisitions. And what is a merger? A merger is defined as an amalgamation or joining of two or more firms into an existing firm, or to form a new firm. And it also defines an acquisition as the acquiring or agreeing to acquire directly or indirectly through shares, voting rights, or management of control, or control over assets in person. All these are regulated, and the primary consideration is control. Are you acquiring control? And does that control that you're acquiring over or the entity result into an adverse effect on competition? And so I'll start with, so maybe let's first go on the next slide, which talks of what the concept of control under the Competition Act. So the control means the right to exercise restraint or direction over another person. And the threshold is slightly lower. I think in most other acts, they look at 50% or more. But in this Competition Act, the threshold is 49% or more of the voting rights. If you acquire 49% or more of the voting rights, they also look at control of the board, and then they also look at controlling the affairs of the other person. And this may be done through other agreements. I think in the Electricity Act and other sectors, they have a broader definition of control. But this act gives that additional covers, it's not as specific, but it also covers those other instances of acquiring control through this general provision that says, controlling the affairs of another person. Then for private equity and venture capital funds, control is deemed to rest with the general partner. So if there's a change in the general partner, this automatically triggers a requirement to notify your merger. So going back to the previous slide, the Competition Act introduces a requirement to notify any merger, acquisition, or joint venture to the ministry. What's important to note is that non-compliance renders the transaction void, and there are penalties. The timing of the notification, when do you notify the competition, the Ministry of Trade and the Technical Committee? Immediately upon board approval or conclusion of negotiations of the transaction. This is before you sign or conclude the deal agreements. Then who has the obligation to notify the regulator? The obligation is on the purchaser or the person acquiring control. If you're not sure, if in doubt or require clarification on whether your merger requires notification, you may seek an advisory opinion with the Technical Committee, Ministry of Trade, and upon notification, the Ministry, upon notification of the merger, the Ministry has an obligation to inquire into the merger to determine whether it is likely to cause an adverse effect on competition. Important to note is that there is a requirement to publish the details of the merger in a newspaper of wide circulation for 14 days. And during its investigation, the Minister has powers to invite affected parties to file written comments, objections, or other representations to confirm whether this merger may have an effect on their business or on competition in that market. So the nature of this inquiry, the Minister may conduct interviews similar to exactly what Mr. Makongo said for COMESA. They will go into the field, conduct interview. They can receive oral and written submission. They can consult with other government of Uganda agencies. So, for instance, for the sector, sectoral regulators, the Ministry of Trade will consult with them. It will convene hearing conferences and invite all persons likely to be affected to make submissions. For the person that registers that requests for the merger to be approved, or that notifies the merger, they may be required to provide information, and this information must be provided within 21 days. Failure to provide this information, your merger will be, you'll be deemed to have abandoned your merger. The Ministry has 120 days, that's 4 months, to make a decision. And if you don't receive a decision within the statutory period, then your merger is deemed approved. And if the authority comes back and deems that there's no adverse effect on competition, it may approve the merger. If the Ministry determines that your merger is likely to affect competition adversely, then the Ministry may issue conditions for approval and will require compliance report. This again is very similar to what Mr. Makongo explained. The Commission under law is required, the Technical Committee under law will be required to issue conditions, either saying that leave certain clauses out or remove certain clauses from your contract, and take these steps to make sure that aspects of fair competition and consumer protection are taken into consideration. And if they make those conditions, if they include those conditions, you'll be required to prepare a compliance report for the Ministry, just to check that you are complying with the conditions of the merger. If you withdraw your merger, so there are filing fees, which we'll look at momentarily, but if you withdraw from the merger, you must notify the Ministry. And it's important to note that there will be no obligation to refund merger filing fees once you withdraw your merger. You may appeal the decision of the Ministry of Trade, either rejecting or issuing conditions. The appeals are made to the High Court. Again, this is a break from a regional trend and in fact global trend, because in for instance Kenya and Tanzania, there are specific tribunals, competition tribunals, just as in Uganda we have, for instance, a tax appeals tribunal, or the electricity tribunal, the insurance tribunal, which here certain appeals made by the relevant ministries. So in this case, the appeal was directly to the High Court of Uganda. So what are the considerations for merger approval? Once you submit your merger for approval, what does the Minister look out for? the overriding consideration is whether your merger is likely to have an adverse effect on competition. The other considerations will be what is the extent, is it significant, or whether there are barriers to entry into the market. Will your merger bar other people from entering the market? To what extent will it foster effective competition in the market? What are the available? Do consumers have available substitutes in the market? What is the market share of parties involved? The likelihood of removal of vigorous or effective competitors. They'll look at the possibility of a rise in falling businesses. Then they'll look at the nature and extent of innovation in the market. These are the other public interest aspects or factors that I alluded to when they're doing market investigations and determining whether a specific act is anti-competitive. Similarly, for merger control, they will also look at whether the benefits of the merger outweigh the adverse impact of the merger. And they will also look at those non-competition factors, again, public interest concerns, whether will it increase in employment, technology transfer, and economic growth, and whether those outweigh any perceived impacts, negative impacts on competition. So what are the merger thresholds? So in determining whether a merger is notifiable, the law, the competition regulations specifically have provided notifiable. What is a notifiable merger? And they look specifically at notification thresholds. This again is very similar to the COMESA analysis, where they look at the combined annual turnover and assets, whichever is higher, of the acquirer and the target being the entity in Uganda that is being acquired. So where your merger is between the value of the assets and annual turnover of both the acquirer and the target exceeds 1 billion shillings, but at least 500 million is attributed to the Ugandan entity, then that is automatically a notifiable merger. These thresholds are significantly low. I think all practitioners in this space will agree that most of the mergers, especially the cross-border ones, exceed this threshold significantly. Then that's the general threshold. Then you have one for competitors or entities that are likely to be vertically integrated. It's a slightly higher threshold of 10 billion. But again, which in comparison to the kind of mergers that are taking place in Uganda from practice is a significantly lower threshold. There's also a specific threshold for carbon-based minerals. These share transfers or rights and assets transfers for companies that own at least that own rights in the oil and gas and coal sectors. The threshold is also 10 billion, again, relatively low, which means it brings almost all mergers or asset acquisitions bring almost all of them under the fold of merger control and regulation. Then for COMESA, as Mr. Makongo explained in detail, again, due to the harmonization efforts, this was captured within the law, the competition regulation specifically, and where a merger meets the COMESA thresholds of 60 million combined annual turnover thresholds and the geographical requirements, then that merger becomes notifiable to COMESA with a right to notify or just a right to keep Uganda in the loop, but without a requirement to formally file and pay filing fees to the Ugandan entity. So you notify them just for visibility purposes, but not for paying and have them review and approve or reject your merger. Then there's another category of what they call exclusion applications. These are mergers which have combined, where they meet the threshold of combined unmanageable assets of 500 million to 1 billion. Here you have the discretion to specifically request for exclusion, especially where your merger is not likely to affect competition in that market. You have to apply, and I think the response takes about only 14 days. And then also in the carbon-based mineral sector, if you're just prospecting, there is no requirement to make a notification to the technical committee. Which mergers are excluded for approval? Mergers that don't require approval under the new framework. Where your turnover and assets are below 500 million, there's no requirement for obvious reasons. Then where you meet the COMESA rules, however, less than 2/3 of the turnover or assets are in Uganda. So I'm sorry, where you meet the COMESA thresholds and less than 2/3 of the turnover or assets are in Uganda, then there's no approval required from the COMESA. This again ties into the notifiable mergers. So, sorry, for whether a merger is notifiable to COMESA, it's a two-pronged test. So they'll look at whether you meet the thresholds, the $60 million thresholds, and two, whether 2/3 or more of your turnover or assets are in Uganda. If your turnover or assets, 2/3 of your turnover or assets are in Uganda, irrespective of whether you meet the COMESA thresholds, you'll be required to notify in Uganda. But if you meet the COMESA thresholds and less than 2/3 of your turnover or assets are in Uganda, then you're required to notify COMESA. The critical gap that has been heavily discussed, I'll not cover that again, is the EAC. You now have the EAC operational, and what are their dual filing requirements. For now, it appears that they're there, but I understand they're, there's an effort to harmonize this and specifically indicate where you file when you meet the EAC thresholds. I believe the EAC thresholds are about $35 million, which is less than COMESA, but more than Uganda. Then other excluded mergers include JVs that are not full function. Remember, joint venture is defined as a person who is subject to joint control by two or more undertakings which are economically independent of each other. So in the market, you normally see in practice, especially for oil and gas, some entities will sign a joint venture agreement, but never go all the way to have that joint venture registered as a separate independent body and what we normally call a special purpose vehicle. So where you just have an agreement and you don't go forward to create an independent company or a standalone company, then there's no requirement to notify that merger. But where you do file an SPV or create a special purpose vehicle for that joint venture, and it's likely to have an adverse effect on competition, then it becomes a notifiable joint venture. Then also notable is that group restructurings, where there is no change in control and mergers concluded entirely outside Uganda with no connection to Uganda, are not notifiable, or there is no requirement for the ministry's consent. So this slide has what are the filing fees, where the merger, the combined turnover or assets are between 500,000 and 500 million to 1 billion Ugandan shillings, then there is no requirement to pay notification fees. Where it's between 1 billion to 10 billion, it's just 1 million shillings. And then you have 2 million shillings for mergers up to 50 billion, and above 50 billion is 4 million. I think those are manageable in the context of the amounts, the value of the transactions. Then the current enforcement landscape. How is the Ministry of Trade looking at these applications? Because the law came in 2024, which required notification of these mergers. There were no thresholds, which only came in August this year, giving authority to determine these merger issues to a technical committee, to the Ministry of Trade assisted by a technical committee. But as I've indicated, this technical committee has not been set up. So as a lawyer representing a client on a merger transaction now in Uganda, what is the current enforcement landscape? How is Ministry of Trade looking at this? So for all mergers with cross-border effects, these are being forwarded to COMESA. And I think the Commissioner of Trade will give us more details on this. For purely domestic mergers, the ministry is currently receiving and handling them internally. The forms and other administrative apparatus has not yet been set up. So these applications are currently being made by formal letter to the ministry, which considers and responds. And then for sector-specific enforcement, remember under all these sectoral competition frameworks, there are specific merger requirements, some of them which are even more, which are stricter or more robust compared to the ones in the Competition Act. You still have to comply with those, and they will be handled specifically by the respective, what is written here, but they will be handled by that sector regulator. So looking at penalties, gun jumping is like a technical term used in competition, and it generally just refers to where you do not wait for ministerial consent or approval of your merger and do the merger without getting the consent. What are the penalties for this? So one, there's a general prohibition, and you must get the notice before entering into a merger, acquisition, or a joint venture. The first impact or implication of you not getting that notice is that it renders the entire transaction void from a legal perspective. And then in terms of financial penalties, the Ministry of Trade can fine up to 10% of the annual turnover of the two merging entities upon conviction. What is also notable here is that there's personal liability for directors, managers, and officers who are involved in the transaction in respect of the two entities may obtain they have individual liability and may be sentenced to imprisonment of up to 10 years. Then also remember that the sector-specific regulators also have additional pre-approval obligations, and there are some under the Financial Institutions Act, there are some under the Uganda Communications Act, again, which charge a percentage of the annual revenues. So what are the key takeaways from this, from an advisor or a lawyer's perspective advising clients in this space? One, we now have a new competition compliance framework. It's broad. As we have seen, it regulates not only mergers, but also conduct, that is anti-competitive practices as well as abuse of dominant position. I think it is our duty as lawyers to inform our clients of this new compliance framework. And we must encourage our clients to compete and plan for compliance during this phase. During this stage, specifically the technical committees in transition and capacity building phase to avert the harsh penalties that I previously spoke of. Then companies with significant dominant position or significant market share, as we have seen from cases coming out of COMESA and other regulatory bodies. So companies with dominant their agreements undertake changes to practices before the complaints. The practitioner in N1A practitioner in the mergers and acquisition space. One so for an advisor in the mergers and acquisition space, one before taking on during the structuring phase, if your merger has one, you must determine whether it is going to be notified in Uganda, whether it has to be it's notifiable at COMESA. I think we have been doing the COMESA ones, but now we have an additional regulation, layer of regulation, determine whether it has the additional compliance requirements under Uganda. And how do you do this? First, you analyze the thresholds. Do we meet financial, which I have just gone over? And once you look at those thresholds, if it goes outside the Ugandan thresholds, or does it meet the ESC thresholds? And if it meets the thresholds, where is most of this value coming from? Is the value coming from Uganda or another member of Uganda, or another member of ESA or ESC? So, for instance, if you determine that 2/3 of that of your clients, combined annual turnover of your clients, either your client being the acquirer or the seller, whether 2/3 of that is coming by a party from Uganda. The moment you make that determination through obviously review of things like the audited financial statements, then you know that that is a transaction that is going to be notified in Uganda, irrespective of the fact that it meets the COMESA edition threshold. And then if it meets this in time, the ESC thresholds, and it is is coming mostly in another country other than Uganda, then you can know that the transactions are going to be notified out of Uganda. For clients in the regulated sectors, I think now it's also supporting them to navigate almost a dual requirement for regulation. You have to get whether does it make sense to regulate to file that competition, the merger approved in the sector, with the national regulator, that is Ministry of Trade. So also to note, as Mr. Makongo indicated, and the most perpendicular Vice Chairperson Violex noted, this with every new framework, there are also new opportunities. It creates new opportunities for lawyers have opportunities to join the technical committee membership, to advise. I think the technical committee making certain decisions may consult with advisors or people who are more knowledgeable in competition. So if you position yourself as a person knowledgeable, then you may have access to those opportunities. Then there are advisory opportunities, obviously, from a merger and from a merger control perspective. And then you also have representation, as Mr. Makongo indicated, before COMESA, the ESC, and our own technical committee. So gaining knowledge in this at this stage, while it is still novel, may give you significant traction going forward. Then obviously monitor the trends. It's new, so it's a landscape to monitor. In practice, there will be so many changes. We've talked about how that sectoral interface between the sector regulators and the technical committee, Ministry of Trade, are going to be managed. It's something to watch so that we advise our clients appropriately. So I'll leave with a parting shot that says the cost of reactive compliance in future will far exceed the cost of a proactive review and adjustment to business practice now. This is what we must tell all our clients. do your review now and prepare for what's coming. Because if you look at the size of the penalties and some of the decisions that have been made by the other regulatory bodies, whether it's at regional level or the other, for instance, Fair Competition Commission in Tanzania and the Competition Authority of Kenya. These are significant penalties. They have reputational implications for the companies involved. So it's far better to make the move now to comply than wait to be forced into compliance later when the Technical Committee and Ministry of Trade begin operations. With that, I conclude my presentation. Thank you for listening.
Thank you so much, Sophia. I think I can truly say that this presentation was comprehensive, and for anyone who is just getting an insight into what competition is, what is the law, what are the regulatory institutions that govern this area, I think really you're giving us a firm introduction, a firm foundation upon which to build. Sophia, I have only 2 questions, and perhaps if there are questions from the members, I'll also pass them on to you. But given that we're pressed for time, I'll only ask these 2 on my side. The first one is, as members of the ULS and the people attending this call, in addition to being lawyers and advocates, the first obligation we have to our clients is that role of a trusted advisor. You advise the board, some of us are company secretaries. The company needs to take their direction on the law and these regulatory aspects from us, particularly in sectors, unlike banking and telecom, which are heavily regulated, and already there are maybe sectoral competition laws where those banks, those telecom companies are alive to these competition aspects. But if you look at things like manufacturing, if you look at things like transport, even for our sector as lawyers, when you're running a law firm, what would be the biggest blind spot that you see, right? For us as the membership of ULS, to guide our members and say that from a competition perspective, this is the 1 or 2 or 3 things that you need to keep at the forefront when you're performing your role of a trusted advisor, right? Should they be focusing on, anti-competitive agreements? I don't think the majority of people who are advising are dominant players. The very definition of dominance, there'll be a few dominant firms. But what blind spot do you think tomorrow a person advising the client should keep at the back of their mind, should tell their client, so that the client can be compliant and avoid those hefty fines you've talked about of 10% of gross annual revenue? Mm-hmm. Sophia, I think you're muted. We can't hear you. Sophia, you're still muted. We can't hear you. And it's not every day that I get a chance to fire my boss hot questions. So please bear with me. Unmute. And yeah. Yes, we can.
Advising their clients, there are 2, maybe 3 areas that should emphasize. One is for especially people in manufacturing that you have mentioned, look at exclusive supply and distributorship arrangements. These are low-hanging fruit, and these have been tested in the markets across the border. So obviously the competition, the technical committee coming into operations is going to have a good benchmark from which to stand to then enforce the same in Uganda. So look out for those exclusive supply, exclusive arrangements, especially for players that have a dominant position within the market. also look at advise their clients from a consumer protection perspective. The technical committee, although I didn't look at this in detail in my presentation, but the technical committee has the powers and function to regulate consumer protection within Uganda. So if someone files a complaint today under consumer protection, then you may find, your client may find themselves at the difficult end of the law. So it's something to also look out for. Then again, the overall consideration is a review and a look at practices and conduct that may affect competition. So if I was advising a board, it would be to look at, before entering into any transaction, any significant transaction, do a competition analysis, whether it is a supply agreement, whether it is that that manufacturer is entering into acquiring significant assets or entering into some kind of merger or joint venture, run a competition analysis and make sure that you're doing it in compliance with the competition laws. Because now that it is in force, we have seen other regulators that were established and then they come back to haunt you 5, 7 years later after the fact. So right now, the focus is on compliance and how those manufacturers or players can structure their dealings to comply with the Competition Act and regulations.
Thank you, Sophia. Perhaps the last question that we would ask is now really focused on the membership. For a lawyer wanting to develop competence in competition law, it's a steep learning curve that you face. There is economics, there's regulatory procedure, there are cross-border frameworks. Are there any resources, experiences, or entry points that you'd recommend to us and say that for someone looking to build genuine capacity in this area, right, this is the track that you should take so that you become a trusted and visible expert in this particular field? Thank you.
This one is a good start. I think around competition is important now, especially when the framework is still very young. And we are yet to see how some of these provisions are going to be effected in practice, or how the technical committee is going to enforce them. It's important to participate in all engagements. And these are, again, as I've said, CL is like this. The Ministry of Trade also has their own efforts. I think they've had engagements with lawyers and other people within the market to understand what they're doing. I think Mr. Zaki has an open door policy. Mr. Zaki and his team have an open door policy at the Ministry of Trade. So regularly check in and find out what's happening, what's new. Then on a regional basis, follow the trends. I think the COMESA Competition Commission has one of the most robust websites with information on their decisions. They have information on the laws, practices. They have information on guidelines and different protocols. So there's a lot of information to be obtained there. Then also there are other regional blocks. There are certain matters which have not yet been tested in regionally, but they may have been tested in the EU. So you know that our technical committee, once set up, if it fails to find a precedent locally, it's going to run to the EU and some other regional blocks. So also find out, interest yourself in finding out what's happening there, what are the trends, because chances are that what's happening there is coming to Uganda near you in the not so long future.
Okay. Thank you so much, Sophia. I think we've learned a great deal. Personally, I'm ready to be the visible expert by attending the CLEs in future. But thank you so much. We truly appreciate the time that you've taken. We hope that you can remain with us so that we can have your parting shots at the end and to answer any questions we might have from the plenary. Okay? Members, I'd like to invite our third speaker of the morning, Mr. Zake Kalega. He is the Commissioner of Internal Trade at the Ministry of Trade. This particular subject that we're talking about falls directly under his docket. Mr. Commissioner Kalega plays a central role in Uganda's trade policy development and is at the forefront of the operationalization of the National Competition Policy, the Act, and the regulations. He brings deep insights into the government's regulatory philosophy, institutional alignment, efforts, and Uganda's obligations under the COMESA and ESE frameworks. He is a focal person in the ministry's efforts to regulate monopolies and protect consumers in Uganda, and he regularly represents the ministry on policy matters including trade facilitation, illicit trade prevention, and private sector competitiveness under the National Development Plan 3. Mr. Kalega will be the focal person and main contact person for competition in Uganda, so I think we need to really listen to what he has to tell us. Mr. Kalega, good morning. Please, the floor is yours.
Enough?
Yes, you are. Yes, you are. We can hear you loud and clear.
Be very visible. Hopefully, at that angle, I'm now visible.
You're very, very visible.
Good morning, everybody participating in this engagement. Like I've been introduced, my name is Zake Kalega. I'm the commissioner in charge of internal trade and also the one in charge of ensuring that the Competition Act is operationalized. But also, I want to tell you that I'm a commissioner in the East African Competition Authority, the authority that has already been alluded to by some of the previous speakers. Much of my work has been done by the previous speakers because I thought I would be taking through the policy, the legal framework, that is the Act. But I know Ms. Nampij has really done a very good job at that. However, I want to give a background on where we are coming from, where we are, and where we want to go. In 2014, before the Competition Act, the ministry approved the National Competition and Consumer Protection Policy as the enabling framework for generation of legislation in competition and consumer protection. What was most important in that policy was that of and addressing competition and consumer protection is of the economics, the trade. Like the earlier speakers have said, you will find there are other acts on competition in other sectors, insurance, banking. But when you look at all of these legislation, they are mainly focusing on income and even others, but they are not. So there was no central area where, for example, if you had a consumer and you have a consumer issue and you had to seek for redress, where you would go in case the statutory authority has not provided the guidance or the advice that you are satisfied and comfortable with. So after recognizing that, the government thought it prudent to have a central and a coordinating authority for competition and consumer protection matters, and that is how we are coming up to this level of having the ministry all in this. But again, the issue of the policy was in some jurisdictions, you'll find that the policy is either at, the laws are valid. You have a Competition Act separate from a Consumer Protection Act. Others are combining both the Competition Act and the Consumer Protection Act as one law. So the ministry decided, or government decided, that we have ours separate. And part of the delay for this Competition Act was as a result of those further consultations independently, looking at, because if you look at the administration of this act, like some other earlier speakers have mentioned, the act in other jurisdictions, the acts are enforced by independent commissions and authorities. That is what we had earlier proposed, and the law went up to parliament level. But of course, as a result of government policy change of RAPEX, we had to look at now an arrangement where the ministry will be implementing this law. But this is an interim arrangement, but in the future we hope to become more autonomous in that particular aspect. And if you look at the case of Kenya, for example, they also started in the ministry and eventually went up to that. And luckily enough, one of the reasons of rationalization was to eliminate agencies that did not seem to generate income for government. But if you look at the aspect of competition, the authority to be prevented can be self-sustaining in terms of finances, especially from the major fees that are collected during notification of money. So eventually, we are able to come up with the act, which was assented to and gazetted in 2014. So that is on the 19th of April. However, the Consumer Protection Bill is still under review. It was approved by the Attorney General, and it is now soon going to be submitted to Cabinet. And it is also adopting the same implementation arrangement as in the Competition Act. So that is where we are. That as regards the regulations were gazetted, and they are in the process of printing, and we expect before the end of the year, we shall have the final copy of this regulation. The regulations are very critical because they rationalize significant provisions in the Act, especially on areas to do with those forms and files, the thresholds for mergers and acquisitions, the technical committee composition, the terms of reference of the technical committee, and the other determinations. So we hope that we shall have this regulation. It has taken some time, and we have the last regulation that was supposed to be printed had some errors in it, so we had to withdraw it, and we have now a final version, which will be soon out, maybe before the end of this year. However, there are a number of issues that have arose in the earlier by the earlier speaker. But what I want to also to inform you is law matters of competition and consumer are relatively in our country, and even at the consumer level, even at the business level, many very competition. So as of the ministry, we are currently engaged in a massive penetration, and I'm happy for the Uganda Law Society given competition and consumer protection policy and law. We really appreciate this. So a lot of awareness is needed, Because if people are not aware of what competition addresses, then it becomes a challenge. So we are putting much of the emphasis in the start on creating awareness on competition and consumer related matters. We have had several engagements with the lawyers themselves. Some of them I see are in attendance in this meeting, but we have also had to create awareness among other policy makers, the sector regulators, including the Insurance Regulatory Authority, the Uganda Communications Commission, Bank of Uganda. But we are also, as a ministry, trying to strengthen our capacity as in terms of technical staff and the resources that will be needed to implementing this law. We are doing a lot of studies for our staff and training, but we have also had the chance to do some exposures to other competition authorities. Early this year, the ministry went to the Kenya Competition Authority and were able to get practical experience on how this. But we have also had a lot of engagement with the Commercial Competition Commission. Like they have already alluded and told you that even before they determine the mergers at the commercial level, the input of the affected partner state is also very critical. So during this arrangement, we have also gotten a lot of learning and experience that will enable us effectively implement the law. So another area we're also looking at under the roadmap, the ministry, matters of competition can be determined when you understand the relevant market and the product. So the ministry is also now putting a lot of resource and effort into understanding the particular sectors through scoping studies and also market screening studies. We have so far had studies in the fertilizer sector. We are looking at the pharmaceutical sector. We have looked at the finance sector. We are also looking at the commercial sector, such as the FTA, we're able to also understand the dynamics of what particular sectors. I can give you an example. When I interacted with the practitioners in the pharmaceutical sector, they were telling us that matters of competition do not apply in the pharmaceutical sector, and we could see what challenge or what kind of task we had to handle some of these matters. But as we discuss, they are getting on board. So the ministry is currently concentrated on screening and scoping studies that are going to help us to understand the dynamics of these particular sectors and the markets. So ideally, that is what we are on currently. But again, we are also in the process of establishing the technical committee. After the regulations have been printed and because we are already gazetted, we shall be able to now look into identifying some of the persons that will be on this technical committee. But like they have already indicated, the speaker earlier, Ms. Nampija, has already indicated that somebody to be on this technical committee, it should be somebody knowledgeable in matters of competition and consumer protection. But again, we are looking at it in a way that we shall also, because the number is only 7, but we shall continuously co-opt other members if a particular case arises that may need input of other advisors and technical people on this arrangement. So when you look at another matter that has come up is a matter of reference of competition matters, the ministry. Like I earlier said, there are already existing regulators who are the different sectors. But now, in this new act, all matters The authority is the ministry. And the spirit of the act is that we are going to be working very closely with these sector regulators to ensure that we don't create any conflict and come up with very harmonized positions as we handle these matters of competition and consumer protection. An issue I want to speak about is an issue of the autonomy. Somebody has been mentioning that how will the ministry be autonomous, especially where government is doing business. This is an issue that arose, and we are working towards ensuring that that does not happen. If you look at matters of competition, even at the ESC and the COMESA, of course, sometimes issues of politics might come in, but of course there are systems to address this, especially when it comes to matters of public interest. We are still discussing what autonomy is. Even if you look at these authorities, their autonomy, I don't know, because they also report to, you find it is a competition authority, but reports through a ministry. It is an agent of a ministry. It is a part of maybe reports to parliament in some jurisdictions. But you find again, you cannot say they are completely autonomous, because even in all of these structures, the influence coming out of a public interest matter. So we had earlier proposed to have a separate entity, like I've earlier said, but that wouldn't happen because of RAPEX. But we hope that in the future we shall be able to achieve that. What I want to stress is that competition and consumer protection matters are matters that need a lot of awareness, a lot of capacity, because these are new areas. If you look at, for example, we are also finding it a challenge, even if you look at in our education system, you'll find that competition is not an issue that is real, even at institutional level. You'll find we don't have universities that are teaching competition law. Some people have to go outside of the country. But there are also other stakeholders in this arrangement. The courts, we're also looking at the mechanism of how we shall engage them to create awareness of these judicial officers on how they are going to handle these matters that will be referred to them. So those are the critical areas I thought I would bring out in this presentation. The act has been fully and well been presented by Madam Nampija. I don't want to go into the particular provisions, but we say we shall commit to continue having engagement. The ministry is open. Maybe another area I wanted to emphasize is that let's work together, because because it is the authority that can determine whether the merger is notifiable here or it is a COMESA or ESC matter. So don't take it upon yourself and sit in the office and say, now from my analysis, I have engaged and known that this matter do not need to come to the ministry. Please, I advise that you always notify these mergers, then the ministry will competently advise whether the merger is supposed to be reported at this level, or it is a cross-border merger that either goes to the ESC or COMESA. As I said, I sit on the ESC Competition Authority. As the company, we are currently working out a framework on harmonizing between COMESA and the ESC. As you are aware, Tanzania is not part of COMESA, and you find a merger might arise which will require ESC. But there are also other threshold limits that we are discussing, and there will be a concrete framework such that we don't have double notification of COMESA. We have a lot of programs and committed to giving a lot of capacity building and training for the relevant stakeholders. And I think now this gives us a chance to engage Uganda society. Always when we have this kind of training to identify and get some of your members to participate in this arrangement. I know much has been said, but those are the areas I thought as a ministry we can add to what has already been said. And I want to thank you for listening, but also to say that we are always available in the ministry to work together to ensure that we effectively and efficiently implement the competition law. I thank you.
Thank you so much, Mr. Kalega. Thank you so much for the very detailed and informative presentation. We, Uganda Law Society, and as the members of Uganda, take advantage of that open door policy that you've mentioned, together with the ministry, to ensure that the Competition Act really helps in the development of the country. Mr. Kalega, in the interest of time, I'm only going to ask you two questions as well, and these questions are interconnected, so I'm going to ask them together. The first question really is that if today I woke up and I'm, let's say, a lawyer for a company, and I realize that this company that I'm advising is not... Okay. Oh. And I realize that this company that I'm advising, for one reason or the other, is not compliant. Is there a grace period? Is it okay if I come and I declare myself and I say that, in truth, I've realized that maybe this exclusivity arrangement I have with my distributors or my suppliers is not compliant? Kindly give me a grace period to comply with the law, and these are the steps that I'm going to take. Then the second one, which is connected, is there any plan by the ministry to have any simplified guidelines for SMEs and smaller businesses, really, which may not be able to afford the administrative costs of hiring, let's say, Martin Sekatawa on this call or Miss Sophia Nampij on this call, but who nonetheless need to comply with this law to be good corporate citizens? Is there any effort that maybe ULS can support in preparing guidelines, perhaps as under the Pro Bono initiative, for these smaller businesses which cannot afford a lawyer? So, Mr. Kalega, those are our questions. Perhaps we could receive your responses.
Thank you so much, Mr. Mgaura. On the issue of non-compliance, we recognize, like I earlier said, that the level of awareness is still very low. Actually, I can give you a case. In some jurisdiction, the Competition Act came into place, but they handled their first case conclusively after almost 7 years. And what were they doing? Awareness creation, and awareness creation. So that is why we are also struggling to ensure that people are aware. But what I also want to mention is that competition law is not here to frustrate or kill business. The issue is that we are here to facilitate business to play in a level field. And you find that many of the decisions that are being taken, even in other jurisdictions, are not always contrary to what is expected. So we shouldn't look at the competition police officer who's trying to find fault and do that. No, we are here to assist. So in that particular case, that's why we are focusing more on awareness creation. But even sometimes, if you look at one of the issues, is that before even we go into an investigation, we can call you and say, show you, and at that level, you can also realize that what you are doing and change. We have had cases where we give opportunity and the people change, even minus going into the detail investigation and that decision making process. So it is something that we can look into. Then you talked of, yes, the ministry has a program of coming up with simplified guidelines, and this is among the issues. So we shall also be working very closely with you to ensure that these guidelines are disseminated, and we also work together even in the development of some of these guidelines to ensure that they are simplified to the level that even an ordinary Ugandan can be able to read and understand.
time that you've taken. And we hope that you can stay around for conclusion. Understood, understood. We'll make sure that perhaps in the next 15 minutes we are concluding. Understood. Okay, members, as we wrap up, I would like to invite Mr. Martin Gold Sekatawa, who is a member of the transactions team at SM Chambers, formerly known as Shinobi Musoke. Martin is an associate. He holds a Bachelor of Laws from Makerere University, Uganda, with merit. He holds a diploma in legal practice from the Law Development Center and a postgraduate diploma in tax and revenue administration from the East African School of Taxation. He is a member of the East African Law Society and the Uganda Law Society. He specializes in commercial litigation, energy and infrastructure projects, and his areas of practice include banking, finance, litigation, competition law, tax practice, property conveyancing and corporate governance, employment law, and arbitration. He has represented a number of financial institutions in Uganda, including local and regional banks, and he acts for major oil and gas companies in the country. His experience includes advising clients across banking and finance, oil and gas project financing and restructuring, and he has advised individual and corporate clients on mechanisms for debt recovery. He has also advised on the tenability of commercial claims and provided general legal advisory services to a number of clients on transactional matters. Martin is going to speak to us today about this beast that we've been talking about, abuse of dominance. All the speakers today have touched on this subject. In a nutshell, in summary, what it's talking about is the law is saying that there is no problem with you being a dominant player. There is no problem with you having 60% market share, or 3 companies which have that 60% together. It's not a problem. But when you abuse that dominance to squeeze other entrants in the market, or to squeeze the customers, and to take actions which are not justifiable economically, that abuse of dominance will cause problems for, like we said, the other players and the consumers. So the law comes in to curb that abuse of dominance. So Martin is going to talk to us about that. What is it in a nutshell? What is the law proposing to counteract that abuse of dominance? And what remedies and compliance strategies are in place? Martin, are you available? Are you able to begin your presentation? Loud and clear. We hear you well.
Thank you. It is a privilege to be here before you to speak about this mini topic of understanding abuse of dominance in Uganda, the enforcement standards, market power, the emerging sectors, and how as we practitioners are going to deal with the situation given the coming of the Competition Act and the regulations we've heard from the previous speakers. The excellent frameworks provided by Mr. Mapongo on the COMESA regional vision, Ms. Nampija on Uganda's new competition law, and Mr. Kalega on the policy backings of this law that we have here today. We now turn to one of the most dynamic and complex areas of enforcement, abuse of donors. This is where the rubber hits the road. It's where the theoretical power of the regulator meets the practical challenge of proving that a successful, often innovative effort from a company has crossed the line to now, from what would have been aggressive competition into something that will be found as an illegal conduct. So in the next minutes allocated to me, we will focus on how and where the Ugandan practitioners, how will the dominance assessed in our market as Uganda, or where, and the most likely flashpoints in the sector, as mentioned by the previous speakers, we're looking at the emerging sectors and also the sectors that have been there, but are highly affected by this competition law in place. Looking at digital markets and digital and telecoms, utilities, how do they interact with the abuse of dominance, given that most of the players here are nationals who are crude to taking the position of being a dominant player in the market. So I'll start off this presentation with that definition of dominance versus market power. And to translate these provisions into enforceable standards, we must then look at what is the distinction before we get to the play field. So the Ugandan Competition Act, as Ms. Nampija has highlighted previously, is against abusing a dominant position. But how do we then know a dominant position exists if you are a lawyer advising a client? So we have to prove it through assessment of what is termed as a substantial market power. And understanding this distinction gives us a go-ahead, or it's an essential step to see how to avoid being caught off guard. So dominance, as earlier on mentioned, I think Mr. Mapogo and the other speakers, is not per se prohibited under the legal frameworks that have been highlighted, both regional and the national level. But you being in a dominant position then obligates you with a special responsibility not to abuse that position and encourage growth and innovation of the market rather than in the new entry and thriving of the economy, including the SMEs. So, as I mentioned earlier on, defines what being in a dominant position is rather than what a dominant person is. So the dominant position is that position of economic strength. That position of economic strength enjoyed by a person, either individually or collectively, persons form a foreclosure to another person from competing in that relevant market. So when you look at the law, particularly I think section 11, it will define what a dominant position would be in the Ugandan setting. But this is a thread that runs through all the definitions provided at the regional level, at ESC. So basically, is you being in a position where you can independently determine what happens in the market. Now, on the other hand, we need to also define what market power is. It's not defined under the Act per se, but when you cross-reference from the other jurisdictions, like the South African competition law, you will see that market power is simply that firm's ability to behave independently of the competitors, consumers, customers. And if you have this ability, when does it then become a problem? Not everyone who has that ability will be in a situation where they need to be on high alert. But now that leads us to the issue of having substantial market power. And here it describes your ability to keep prices above the competition level for a significant period of time, having control of this market for a significant period of time. I'll take an example. If you can influence prices or give discounts for a Christmas bonanza for a short period of time, it will not per se be anti-competitive. But if you can do this over a period of time, then definitely it will lead us to a position where you shouldn't abuse your dominant position in the market. So it underlies the economic reality and the capacity to influence market conditions. So when you merge the two, that's when you get to a position where you are at potential to abuse this dominant position. So most of the other jurisdictions, including ours, they have an aspect of the market share. But per se, the market share is not the final determinant. As we've heard from the previous speaker, I think Kenya has 30%. And in Uganda, here we're looking at an individual at 30%, aggregate market at 60%. And this is one of the starting points when it gets to our act here. So that leads us to the position of assessing whether a person enjoys a dominant position in Uganda. Now, what we have determined or defined and seen globally, it's purely behavioral and structural as well. To arrive to a critical question for our practice here in Uganda, how will this then be assessed when it gets to Uganda? So we're looking at a situation when a client opens up an investigation against your clients. What specific tests will be applied to determine if it is under our new legal framework? And there are parts to it. So let's first explore how to assess the position in Uganda. Typically, as I've mentioned, market share only. So an undertaking this market share is not a market position of that undertaking, but does not on its own determine whether the undertaking is dominant without regards to the other factors, both under the acts and the regulations. So these were hinted on by the previous speaker, Ms. Nampija, but a dominant position shall generally be determined based off a combination of factors, which when considered individually may not be conclusive. So the ministry here shall assess the specific facts, circumstancing character that relevant market the undertaking is operating before reaching a conclusion as to whether the undertaking holds a dominant position. So under our, it's a hybrid, as I've mentioned, both structural and behavioral. And we've hinted on the first starting point is whether the person is supplying or acquiring 30% or more of a particular good or services. This may be considered dominant, but looking at the oligopolistic nature of markets, where a collective supply or acquisition can happen, then 60% or more by three or other persons may trigger the same scrutiny in this case. So your act then provides a holistic, I think, examination of the undertaking's economic strength and the market context. So these have were to do with your outsourcing and that of their competitors as well on the other side. So we also look at issues to do with the taking advantage. This could have issues of whether we're assessing someone who is having a trademark and who has a high level of customer loyalty. We looked at the aspect of vertical integration. Then we also look at the other barriers available to prevent entry into that particular market. And this could include regulatory houses through this person that is a dominant player. We're looking at issues if high capital costs to the customer or even the person setting the constitution before determining as looking also switching from utility of goods or service from this person to the other. We are also looking at the countervailing power, the bargaining power of the customers in this market. So it is multifaceted. It is an inquiry that aims to determine ultimate interests, the power to act independently in that market space. Then key to note is also that both the products and geographic dimensions. So we will look at all those issues and kind of have a determination as to whether this person not and the regulation is mentioned by the ministry to have a discretion to consider any factors that they may find relevant in order to judge a company or person to be in a dominant position. So I think this was left out in the act for the ministry because of the evolving nature now of the dominancy. So the dominancy is evolving given the of our economies. We're in evolving countries. So issues of emerging sectors like the digital platforms that Mr. Makongo hinted on previously, I think that could be reason as to why the ministry retains that discretion to consider any other factors so that it is futuristic. Now, having looked at what could be the determinants of a dominant position, then we need to move as practitioners. The pressing need is for how do they then treat this dominant position? What conduct by this client here or by the competitor will then trigger liability under the laws that we've looked at previously. And here we will be looking at abusive practices. So having determined who is responsible to prevent anti-competitive practices as a dominant player, then what are those practices? It's what leads us to this next segment where we discuss the abusive practices. Generally, abusive practices are divided into the exploitative abuse. Explanation of the exclusionary abuses are those that drive competitors out of the markets or keep them out or competitors to keep the competition. So those are exclusionary in nature. They can be difficult to distinguish from what one would term tough competition in a market because they look similar to what would be tough competition in a short term. But okay, to illustrate this, we can use the example of predatory pricing. In the short, it could be good for consumers. Looks like prices, but there are more goods, low prices. But in the long run, the competitors, after excluding the rivals, will then hike the prices back to higher prices, or even in fact reduce the quality of the goods. On the other hand, abuses are those where dominant firm raises prices or lowers quality or acts in a way that it enriches itself. It could not if it were in a competitive market. So here you're looking at someone exploiting their customers or consumers. So we will then go into the developments. And this is found under part 4, section 11, 5 specifically. So it's all encompassing. It's a section that gives a wide range of what would amount to abuse of a dominant issue. And this provision here not target a specific victim. If you're having a class competitor, could be a consumer or a supplier. But in the end, we're trying to see that we call the anti-competitive conduct. So if we to look at exploiters under the Act, that would be section 12 of the Act. It creates having a dominant position towards those that are dependent on the goods or services that this particular firm provides. So it moves the discount analysis, but then attempts to address the same balance, bargain power in listed, which would be consumer protection. So it expressly prohibits from imposing unfairly high, unfairly low purchase prices or unfair trading conditions. It prohibits limiting production or technical development or arbitrary disadvantage captive trading partners or arbitrary disadvantage captive trading partners. So when you look at this section, it's the distinction between the consumer aspect and competition as between competitors. So section 13 then goes to the exclusionary side, and I think this actions that will exclude other competitors from the market. So these include predatory explained earlier. If you're selling below predatory explained earlier, if you're selling below eliminators, but there is a possibility of hiking the prices back when you included this rival, that would be considered predatory pricing. And also have issues like refusal to deal or refusal to of access to an essential facility. These have been explored in the telecom industry is to deny access or infrastructure that is indispensable for competition. And then found on the illegal conduct side of the law when it comes to competition. And I think the introduction in the 2025 regulation was on digital markets, and the regulation says in case of the digital economy, the ministry/stroke technical committee on competition and consumer protection shall regard unjustified refusal to supply or grant access to essential data, networks, or infrastructural facilities which are not easily accessible in reasonable terms to another undertaking as an abuse of a dominant position. So in this case, the regulations come out clearly on that aspect of refusal to deal or access to an essential facility. I think we've also had discussions on cases that have been mentioned prior, Easy Money and MTN, where there was a termination of the contract because the person had become a competitor in a way. And the Ugandan courts have granted damages to Easy Money of over 2.3 billion. So from that angle, you see that most of these abuses are ones that would exclude competitors from joining the market. We also have issues of arrangements or banding. So here you're forcing a customer to buy a second distinct product with another. So there is a tied product, a tied product. If you are selling a product, but the issue that says the person should also other products, then that would be a tying arrangement. We've also seen aspects of territorial restrictions. We've seen aspects mentioned by Mr. Makongo at COMESA to do with minimum resale price maintenance. Then we also had aspects of single branding. And just to connect this to the discussion of the international and regional perspective, EU COMESA, we will look at a decision that has come out recently this year in September. We had a decision in DOGC, and what COMESA said here on its own motion instituted investigations as to how Diageo was distributing its products across the common market, of which Uganda was a part of, and specifically in this case, the distribution agreements between Diageo and its distributors had anti-competitive clauses when it comes to a restriction as to territory where the distributor should sell the products that would in turn get into market allocation issues. There was single branding where the distributor could not sell any other brands except from those from Diageo. And the resale prices. So this distributor could not fix a price on their own. And the decision was that it came to an issue that had been discussed prior, some of the remedies, and this is a settlement. So the matter was settled, and Diageo undertook correction measures in the different aspects. It had to pull out some of these anti-competitive clauses. from their agreements and undertook to train its staff and management as to the applicability of these amended distribution agreements, so that they are not caught on the other side of the law when it comes to competition law. This is very pertinent because the particular agreements were applicable to the Ugandan market area. So those are the regional, national authorities or entities of competition law are going to be on the lookout. We are also going to consider dominance in regulated markets. I know my next speaker, the colleague, Mr. Abdul Salam from UCC, has issues to deal with mobile money and data markets. We'll just brush on those. So when you consider telecoms and fintechs, utilities, we're looking at the aspect of most of the Ugandan telecoms that we have are multinationals, which would per se put them in a position of being in a dominant position. We're looking at an example of the telcos, that is Airtel, MTN, and from 2009 to 2025 currently, we've seen a change in the landscape that has only left two major players when it comes to voice calls, that is Airtel and MTN. In between there, we saw players come in. We had Wari, we had Africa, we had issues of managers, we had transfers, and in the end, we were Airtel could be seen as competing in the actual sense. They are reinforcing their dominance as the two parties in the field. This could lead to potential issues of price fixing, you cannot have. And this is an issue that is yet to be tested with the new law in place. Fintechs, still the most rapidly growing area is around financial services platforms, which are also interconnected to major players that I've mentioned earlier, Airtel and MTN. And you would see that MTN Momo and Airtel Money are the key players in the industry, still without any other major competitor when it comes to telecoms, which have the inherent advantage of having data to most of these customers. And if you to connect the points, we have other aspects. I think that this will be touched on by Mr. We have issues of utility paying of utilities and bills. So utility and bill payments is also an issue that most businesses have been boxed into being comfortable with offering the two service providers, Airtel and MTN, not simply because of choice, but because if they don't have the only two, then they are likely to lose out on customers. You can also look at it in the issue of merchant pay. Here we are looking at the developments in fintechs. And when it comes to merchant pays, still the businesses will be comfortable with only these two players, forcing out new entrants or making it difficult. There is also a potential of concerted pricing issues that there is no competition or formidable competition from new entrants. You can also say the same for the recent introduction of the virtual cards. We started with MTN outing its virtual card in February this year, and they are partnering with International and MasterCard. The next seeding month, we see Airtel get on board, and it's all using the same partners, Network International and MasterCard. This is a position, and next other competitors that would want from Uganda to achieve that objective. So that is a discussion I think it will be viewed on by the perspective of the sectorial regulator. And the other is on utilities. When it comes to utilities, this is an interesting area because most of the legislations that we have in the different regions are tested that situation of where you're having one single company put in place either by an act of parliament to supply an essential utility. This is looking at water distribution or and in that sense, with law, with the situation from our different jurisdiction exploration, and this is going to be an interest, as most of the speakers have mentioned. It's a new law, so most of the things are yet to be tested out. But this kind of electricity or water, what other jurisdiction continuous assessment of these service providers, to which I think consumers may still be or have issues to raise. The Act gives a liberty for any aggrieved party to raise an issue with the ministry and have the matter investigated. And this will be tested. I know Uganda, its nature and litigious population, we will look at someone litigating about these service entities to sole providers. And I think then that takes us to the aspect of remedies and compliance strategies. As a practitioner now, if you want to test out whether your client is in an abuse of a dominant position, or if they're found in abuse of a dominant position, what remedies do we have? The first speakers also hinted on and I think as practitioners, our starting point is to do that competition analysis for our clients. We have to look at what they have in place now as to whether they are compliant to the standards of the new law. If this is assessed, then we can also move to check what can be done after assessing this. And for the new entrants in the market or mergers and acquisition, we need to be proactive as to the aspect of the regulatory overlap, checking with the sectoral regulators before we can actually put in that merger notification. And also being knowledgeable about this subject is going to be very key for the practitioners in order to tell where to notify, given it's an issue, and our clients need to be well abreast. So, as the ministry has also mentioned, they are having these talks about competition. I think with time we will be there. So the other remedies you can have from the case discussed of Diageo, you see that settlement is also another remedy here. In order to reduce on liability, and one of the questions that came up was, I think I've overshot my time on this, but basically we can conclude with the settlement. And generally my parting shot is that dominancy is dynamic, it's evolving, so we need to be in the know of the new trends and better advise our clients in that direction. Thank you. I will end that.
Thank you so much, Martin. You've done the topic justice. I think the membership is now aware about this thing we're talking about, dominance and abuse of dominance. I think our clients will be the beneficiaries of this space. And again, thank you so much. Martin, I noted that you gave your parting shots right after that. So I'm going to just invite Mr. Boniface Makongo to give his parting shots as we conclude and wind down this session. And thereafter, I'll invite the other speakers to also give their parting shots. Mr. Boniface? Mr. Makongo, if you're speaking, you're muted. We can't hear you. Okay, as we resolve that technical issue, I'll ask Mr. Kalega to kindly give us your parting shots, your conclusions, and any recommendations for the membership.
But I also want to thank the Uganda as a ministry. We are really very, very grateful to this, and we committed that in this agenda. I know it has been short time, matters of competition time. We shall matter, and hopefully that together we shall have further engagement together to ensure that much of this information is shared amongst your members. Ours is that as a ministry we are ready and we have to begin, but I had earlier alluded and said that matters of competition need a lot of awareness creation, and that is what we are embarking on, but also carrying out a lot of studies on the particular sectors to understand the dynamics that are there, and we are committed to that. However, we are also calling upon you to really pass on this information to your clients, to the business people, such that they are aware. And I call upon you to always engage with us in the case of any issues that may arise, and to promise that we shall always be at your disposal and make sure that we work together. Maybe Mr. Mugaro, I hope that the members get copies of the presentations we have made, but there's also another information. We shall, as a ministry, give some copies of the law, also so that you can have some copies of the policy for people to further read and understand some of these. I want to thank you so much and wish you a grateful weekend. Thank you.
Thank you, Mr. Kalega. We also appreciate the offer of the copies of the law that will be extended to ULS, and we shall make sure that we reach out to the ministry on any issues touching upon competition. Mrs. Nampija, Sophia, if you could give your parting remarks.
CLE. We hope that there will be many more other engagement in this issue in the next year. I think my parting note greatly from Mr. Zaki, the birth of a new legal frontier in Uganda. And the Competition Act is not just another statute, it's a new playing field. New rules and new referees. And the question is not if they will face these issues, but when. So as practitioners, let's not be caught on the back foot. Let's start advising and let's start shaping this scape before it shapes our practice. That's it for me.
Okay. Mr. Makongo, I don't know if you are able to give your parting remarks.
Yes, thank you very much.
Area of law, and Uganda has just started by way of implement on this. So, and also we are having the landscape looks very well set out, including the ESC and COMESA. So just to invite the lawyers to develop an interest in this area. And I look forward that going forward, transactions involving Ugandan farms will be submitted to us by Ugandan lawyers. Otherwise, thank you.
Thank you so much. And finally, Martin, if we could have your parting remarks in 1 or 2 minutes. My apologies, Mr. Sekatawa, if we could have your parting remarks in 1 or 2 minutes. Martin, you muted.
Issue. Now I also need to join my voice to that of the previous speakers as we continue Uganda. We just need to encourage the practitioners to engage themselves in all these informative talks regarding competition law and better themselves in the area and COMESA and everything. So just looking forward to how this new law will play out in Uganda. Otherwise, we thank you for this initiative as the Uganda Law Society. Thank you.
Okay. Thank you, my panelists. Thank you, members, for attending. We noticed that there are 1 or 2 questions in the comment section which have not been responded to. We've taken them down and we're going to ensure that the responses reach the lawyers, the advocates who are inquiring about this. As we conclude this session, members, I'd like to just emphasize the following 6 takeaways. The first one is competition protects the right to work. It is part of our constitutional safeguards in Uganda to ensure that the market is fair and it is not rigged by cartels and collusive practices. The second is that fair competition validates our work. It ensures that business succeeds. and that business is done on merit and efficiency and not by market manipulation. The third takeaway would be that we should not ignore the robust regulation abroad, especially at the regional level at COMESA, as we have seen from Mr. Makongo, and at East Africa, as we've seen from Mr. Kalega. Uganda is not an island. Your transactions that you're advising on in Uganda could be impacted by regional instruments. And now that Africa is coming together in the African Free Trade Continental Area, it is going to be all the more necessary to make sure that you are alive to these regional and continental rules that may affect your business. The third is that our duty as trusted advisors, as advocates, is to ensure that we are keen, we are alive to these developments, we have the skills to walk our clients through these transactions. There's nothing as bad as concluding a transaction. COMESA raises a red flag, the ministry raises a red flag, and you're told that all the hard work you've done over 6 months is null and void because you did not get a competition merger approval. The fifth is that this thing called competition means that we cannot work in silos anymore. Competition affects each and every aspect of your practice, each and every aspect. If you're a data protection lawyer, right, and your client, by virtue of the nature of their platform, is collecting data in a way that gives them dominant status in the market, you cannot avoid to say that me, I'll only advise on the data aspects. You need a competition person on ground. If you're in digital trade, if you're in corporate governance, if you're a transactions advisor, these silos must stop. You need to have that unified practice that ensures that you consult across teams and you give your clients advice that will ensure that whatever they have planned can go forward without a red flag, without a question mark. The last takeaway is, please, I'm giving you homework. Go home and advise your clients. Look at all the contracts that you have in place. Look at the structuring. Look at practices which may not be written down as agreements, but which may be anti-competitive by the nature of those practices, and ensure that your client is not the one who's caught out by this law. Thank you so much for your attention. Thank you so much for your attendance. Have a nice Friday, everyone.